Welcome, everyone. Thanks very much for being here with us this morning. I'm Lauren Brinjack, PRLA's Senior Director of Legislative Affairs, and with me I have Zach Pizek.
Good morning, everyone. Zach Pizek here with the PRLA team, and thank you all for joining us. Happy Monday here. We appreciate you, of course, taking the time out of your schedules to be with us for what we know is going to be a very timely and important conversation. As many of you are aware, last week the Pennsylvania Supreme Court issued its long-awaited decision regarding skill games. Many of you might have skill games or you've been considering skill games in your operations. At the very least, I'm sure everyone has seen skill games everywhere. Since the decision, we've heard from many of you, restaurant owners, tavern operators, other hospitality businesses across the state, all asking a very similar question. What does this mean for my business? At PRLA, our goal is to, of course, ensure that you all have access to reliable information to help understand the potential implications of major developments like this, those things that may affect your businesses. So the timing of this decision, I think, is particularly significant. Lauren and I were just catching up this morning. Both the Pennsylvania House and Senate have returned to Harrisburg this week with the goal of finalizing the state budget. A budget deadline of June 30th is looming. Meanwhile, with this decision, the Supreme Court has basically kind of turned the issue over to policymakers for the time being. So as a result, we think there might be a very real possibility that discussions surrounding skill games become part of the broader conversations taking place in Harrisburg over the coming weeks, or even become the conversation up in Harrisburg right now. So PRLA is going to continue to monitor legislative, regulatory developments as they unfold. We'll keep our members informed of those that progress or lack thereof. In the meantime, we felt it was important to bring everyone together. We've got with legal counsel here who can help explain what the court decided, what the 120-day stay means for all of you, what business owners may want to be thinking about during this period of uncertainty. We are fortunate to be joined by two great friends of PRLA and attorneys who have been our chief legal counsel, who have been closely following this issue. Daniel Conlon and Evan Pappas of Tucker Arensberg both have extensive experience advising hospitality businesses, helping clients navigate complex regulatory and legal issues like this. Daniel and Evan, thank you both for being with us today, for being here, for sharing your expertise with our members today. With that, I'm going to turn it over to all of you. Like Eric noted at the top of the call, for those who might just be joining, we kindly ask that you all stay muted during the call. We will reserve time at the end for questions and answers. Feel free to add those to the chat. But without further ado there, Daniel, Evan, feel free to take it away. Thanks for being here.
Thank you, Zach. Thank you. So Evan and I are both shareholders here at Tucker Arensberg. We're also general counsel to the association. We've worked already with several of you. We've had the pleasure of working with several of you. When this decision came down last week and Zach and I had a call, he said, look, there's going to be a lot of member inquiries about this decision. As you know, we've already spoken with several of you on other issues in our capacity as general counsel for the association. So I think Zach and I and other people collaborated in developing the idea of this webinar. And I know that there's probably a lot of questions. Evan and I are going to share a lot of information with you, but my hope is that this can be a little bit of an interactive dialogue as well, where we can get some of your questions. And if we're able to provide answers to those questions here, that's great. If not, we could, continue to have some discussions offline. I will say there is a legislative fix, if you may, to this issue, but I think that both Evan and I are going to approach this really from a legal perspective. If you have questions about how is the legislator going to fix this, or what are chances of having these games in our premises legally, Evan and I don't really have that answer. We're going to communicate the way that the court communicated. And they said, look, we are reading the statute that's on the books, and this is the decision that we have arrived at. So I will stay away from making predictions about how the legislator is going to act in 120 days. Um, Evan, my partner, Evan, do you have anything to add it to our introduction?
No, I think that you're right. I think that for purposes of this morning, we want to communicate what did the Supreme Court decide, and what does that mean for hospitality businesses that may have skill games for now until there is any legislative change on this topic. But until the legislature does something, this is what we're stuck with. So the discussion for now is going to be the status quo until there is an actual law passed in the Commonwealth that permits and or regulates skill games in some way. So yeah, I think that's about all on the intro that I have, Daniel. So if you want to get started,
Okay.
you want me to, I
Thank
don't
you.
care.
Yeah, thank you, Evan. So I want to anchor us in the statute, probably the most important statute where there have been prior decisions in this case. And let me also give you the citation to the statute, because um, this is where we live. This law is in effect now. It was in effect yesterday. It's in effect now, and this is where restaurant own F&B businesses, restaurants who have any of these games will need to be keenly aware of this statute. So that is it's Title 18 PACS 5513. Okay, that's the crimes code. Yeah, 18 is the crimes code, Pennsylvania's crimes code. And that statute says a person is guilty of a misdemeanor of the first degree. Okay, this is a serious statute. It says a misdemeanor of the first degree if he intentionally or knowingly makes, assembles, setups, maintains, sells, leases, and it goes on, any punch board, drawing card, slot machine, or any other device to be used for gambling purposes. And there's an exception, except playing cards. Okay. And here's another part of that statute that we'll be talking about. We also want to emphasize the impact on landlords. So in subsection 4, it says you're also guilty of a misdemeanor of the first degree if you are the owner, tenant, lessee, or occupant of any premises, knowingly permitting or allowing to permit to be used any of these devices for unlawful gambling. Okay, so the history of this case stems from this statute. And what do some of the words in this statute mean? If we look at the rest of section 5513, there is a definition section, but guess what? Slot machines are not defined there, and gambling devices are not defined there either. So because of that, there was litigation over this statute and over other statutes. Most importantly, as the Supreme Court mentioned, there was 2 cases that were kind of the bedrock on which a lot of these skill games were allowed to operate in Pennsylvania. One of the cases is Palm of Pennsylvania versus the Department of Revenue. Interestingly, Palm of Pennsylvania LLC is the company that distributes the software for a lot of these skill games. That's the name of the company. Now, interestingly, if you type in Palm of Pennsylvania, uh, their website is tucked almost on the second page on Google. Most of the references to Palm of Pennsylvania are about this case. So they've really become famous in the legal world because of the litigation. And the other case is the NRED 3 Pennsylvania skill amusement devices, which is the case that reached the PA Supreme Court. And what the Supreme Court did is they said, look, we're going to consolidate these cases and we're going to decide these cases together, right? So the case that was published last week by the PA Supreme Court is titled 3 PA Skill Amusement Devices versus the Department of Revenue, but it does consolidate the other cases. So I don't know, Evan, do you want to add anything to that?
Are you moving on from these two decisions?
Yes, I mean we have a slide ultimately on the decision that the court made. I don't know if you want to address that or
I
should
was going
I?
to say that these two decisions, I want to avoid the complexity because they are complex in their own right. But what these two decisions have done so far before the Supreme Court decision came out was they allowed this gray area to exist within the Commonwealth and created a distinction between these skill games and the other gambling slot machines that we typically see in casinos. And it was based on this fairly difficult to understand concept that differentiated them based on whether or not skill was involved or not. And that's sort of the world we lived in until this Supreme Court decision was decided. And even within that previous landscape where skill games were quickly proliferating through the Commonwealth, there was still some differentiation between certain types of skill games. So, for example, some were okay and some were not okay, depending on how much skill those machines had. And I think over time, I mean, I'm not looking to call brand names out specifically, but the POM or the Pace-O-Matic machines were largely viewed by enforcement agencies as being sufficiently skill-based that they would allow those. So you saw this pretty fast proliferation of these machines throughout the Commonwealth. And now that we have the decision, and we'll get into that in some detail with Daniel, but they said there's no more gray area. They're a slot machine, and we already have statutes that deal with that. So it was a pretty cold ending to the gray area that permitted the skill games. But go ahead, Daniel, and you can elaborate on sort of the details of the Supreme Court decision.
Yeah, thank you. Yeah, the slide we're currently on, this is a perfect segue into the decision that the Supreme Court made last year. This case, the three PA skills amusement devices versus revenue case, ascended from the Commonwealth Court. Okay, and now the Commonwealth Court used, remember I said the slot machines or gambling devices were not defined in that specific section 5513 of the Crimes Code. So in the lower court, in the Commonwealth Court, they said, okay, well, there's no definition there. Let's look to a test, a test. And the test that they had developed in another case was the predominant factor test to determine whether the device was based on skill or is based on chance, right? And if it was purely a game of chance, well, okay, that's a gambling device. But if there was some element of skill, well, okay, that's in the gray area that Evan just referred to. Okay, so that was what the Commonwealth Court said. And after the Commonwealth Court had published their decision, the manufacturers of these machines and the software, I've seen they did like very colorful ads that they would share with tenants that had these devices in their premises, and they'd say these games are legal, right? In bright red, they'd say these games are legal. Commonwealth Court has spoken, right? Something like that. So there was really, after the Commonwealth Court's decision, there was really a license to be able to sell these devices, to be able to take these devices everywhere and anywhere. You don't see them just as restaurants, you see them at laundromats, you see them in hotels, in rest stops, gas stations, etc. So the Commonwealth Court said, look, that we're going to use the predominant factor test. Using the predominant factor test, we look at these devices after you play the first or second level. There is, there is an element of skill involved. Okay. And look, the manufacturers of the software and the distributors, they knew exactly how to exploit this gray area, right? Because they're like, okay, we're going to manufacture the software so that on the first two rounds, it will be chance. It'll be a gambling device. But after that, there can be an element of skill, and we can prove, we can use our software engineers to prove that there is some element of skill. Well, okay, the case gets to the Supreme Court, and they're like, look, you're just playing games. In 2017, there was an amendment, right? There was an amendment to the Gaming Act, and it did define a skill slot machine. Notice the word skill slot machine. So they said, look, the legislator's already spoken here. We don't need the predominant test. Forget all the games here. We have a definition for a skill game. And guess what? That definition says that these are gambling devices. It's as simple as that. They said, look at how the legislator has defined these games. And you don't have to use the predominant factor test to figure out whether yes, it is or yes, it isn't a game of skill. Look at the definition. The definition specifically addresses this device. And because it's defined in the Gaming Act, guess what? It's a gambling device. So by interpreting the statute very, very explicitly, they didn't do any mental gymnastics here. They just said, what you have in your stores is already defined in the Gaming Act, and the Gaming Act says it's a gambling device. So if you want to have these devices, you need a gaming license. So there you go. That's how the Supreme Court decided this case. And if we can go on to the next slide, we can this kind of explains how it is that the court read the Gaming Act in connection with that section 5513 of the Crimes Court and says, look, they don't live in separate universes. They have to be read together. Yes, 5513 doesn't define a slot machine. It doesn't define gambling, but you don't get around it by using your predominant factor test. It's not that hard. Just look at the Gaming Act. And the Gaming Act defines exactly what these devices are. So that ended it. That pretty much ended the gray area. So who's impacted by this? Evan, I don't know if you want to. Evans and I've been getting calls from clients, all over the state, and we're just really surprised to see, how these devices really proliferated so many businesses. But Evan, you want to talk a little bit about where we think the industry is impacted by this decision?
Well, yeah, I think it's pretty clear. The Supreme Court has now said these are not permitted anymore. And we'll get into the 120-day stay in a moment. But for the time being, that gray area has been eliminated, which creates the obligation for business owners who have these or landlords whose tenants have these to make some fairly prompt decisions about whether to continue operating these machines. And I think it's fair to say that when that stay ends, we're going to see some fairly prompt enforcement efforts seeking to confiscate, remove, take monies generated from these machines, and I think it will be prompt, and I think you could expect it to be in large number because these things are everywhere. And I think there may still be some hope that the legislature steps in, but for now we have a no answer from the Supreme Court. One thing I was going to mention, to the extent folks are not familiar with sort of the Commonwealth Court versus the Supreme Court, the Commonwealth Court handles actions that have the Commonwealth as a party. And it is known to be a fairly important court, but our court system operates in three tiers where you have sort of the lower courts, the middle courts, and then the Supreme Court. And the federal system follows that same pattern. And what happened here was the Commonwealth Court is one of our middle courts. And when a middle court says something, that can hold the effect of law for a lot of businesses for a long time until there's an appeal to the Supreme Court. And I think, well, that's what happened here. This appeal to the Supreme Court and their decision now has sort of ended that Commonwealth Court decision on this issue. What does this mean for businesses? I think if you're a skill game operator and you don't have a liquor license, your lens is limited to whether or not you'll be lawful following the 120-day stay and what your potential consequences will be with the criminal sanctions that skill games operators will likely be faced with. And the reason I'm sort of differentiating is I think if you own a liquor license, the level of analysis gets a little bit more complicated because, as you know, you have additional regulators looking at your business, and it would be well, here's our slide. There's strict gambling prohibitions in the liquor code that prohibit you from running gambling devices within your premises. And that's one of the concerns I have, and we don't have precise guidance at this point, but despite 120-day stay on enforcement activity. What we don't know is what does that mean as far as the PLCB's interpretations of whether you're allowed to have these or not, and whether it could be the basis for a citation or suspension of a license, something we have not yet seen, but something that we're concerned with and looking at. So we get into the stay. I mentioned it briefly, but the court obviously recognized the significance of their decision and the impact that it was likely to have on hundreds and hundreds of businesses, probably thousands and thousands of businesses across the state that use these machines. They make a lot of money. For those of you that do have them, they make money for the operators. There's also been several sort of boutique distribution companies that also distribute these throughout the Commonwealth that will also be impacted. It creates an immediate illegality to what was once legal, and the implications are clear that we have to now immediately prepare for what we're going to do. And what does that mean? Does that mean you have to get them out of your premises immediately? Does that mean you just have to unplug these? I don't know that we're ready to give specific guidance on this particular webinar on those points, but I don't think you need to load them into a truck in the back of the parking lot at this point. I think that they're fine to stay where they are, but depending on the operator, you may need to think about whether you allow the continued operation of these machines within your premises. I think that's going to be one of the most important decisions, especially in this 120-day phase where we're looking at whether legislature is going to come to make these permissible in some way. What we want to avoid is creating too much of a disruption for businesses that already have a lot on their plate to deal with unplugging and hauling away these machines and repurposing the space, perhaps, if they're going to be permitted again in a few months. So I don't know that there's a need for panic, but certainly need to start assessing what we're going to do and how we're going to implement those steps if there's not a solution in place as we get towards the end of that 120 days. And I would probably bet most of my savings that Zach and Lauren are going to be giving us regular updates on what legislation may be coming down the pike on this so that we can kind of follow along very closely.
And if I can add two more practical suggestions and recommendations, we have them listed on page 11 of our slide. So if you want to move to jump ahead 2 slides, or yeah, there you go. So yeah, Evan and I are lawyers. We love contracts. We love paper. So 2 of our recommendations are going to be go look at the contracts. You likely have a lease. If you don't, I mean, if you're a tenant at a premises and you don't own the real estate, you likely have a lease. Even if you own the real estate, you might have a lease. But go to your lease, look to this clauses or look for clauses that talk about the use, okay, use of the premises. Check to see if there's any language in there that says that gambling is prohibited, gambling is an event of default, operating illegal gambling or just illegal acts could also be a default of lease. Look at that, right? Because you may just be thinking about the police walking through your doors, but how about your landlord, right? Think about your land. And if you are a landlord, right? At the beginning of the presentation, I read the section that applies directly to you. It's not just, oh, it's the tenant. Or if you're the landlord, there is a section of the crimes code that applies to you for having gambling devices or unlawful gambling. Here's a second suggestion too, very practical. All of these, all of the distributors of the software makers um, have placed these devices at your premises, and there is a contract of some sort, right? That is the foundation of that relationship. Now, a lot of these devices, they are simply being placed on your premises through a license, right? A license. Maybe they are paying rent. Maybe your arrangement is that you pay or you share in the proceeds from those devices, right? There's different arrangements, but what I can guarantee you is that there is probably a document, right, that speaks to that relationship. Um, there may be language in your contract with that provider that says if you face um, any action by the police, by the Bureau of Liquor Control Enforcement, by any Commonwealth agency, and if you suffer harm, okay, because of our devices at your premises, then we will agree to indemnify you. Now, what does that mean? That means they pay the bill. Okay. Now, guarantee that they're going to pay the bill? No, absolutely. Because if they have that contract in every, um, for every premises in which they've placed games, they're either they have a lot of insurance, right? Or they're going to have to be out of pocket a lot of money. But I'm just saying that that's something that you want to at least go to your contract and see if that language exists. Okay. If it doesn't exist, then, that's something you want to know as well, right? You want to know the good news and the bad news. So, again, just to summarize, look at your lease if you have a lease. Number two, look at your contract with the provider of the game devices. So I think that would take us to our last slide. There's contact information for both Evan and I. Evan is in our Harrisburg office. He's co-chair of the hospitality practice here at the law firm Tucker Arensberg. I'm in the Pittsburgh office. We collaborate a lot, but if you need somebody, if you're depending on what area of the state you're located, if you need to meet with any of us individually, well, you can reach out to Evan based on wherever you're located if you want to have a meeting. But we've been talking for 30 minutes already, and if there are questions, Zach and Laura, I defer to you on how you want to handle this Q&A section. But I think we've already put a lot of information out there, and maybe now is the time to take some questions, if there are any, from members and the public.
Daniel, Evan, thank you both very much for the presentation. I would encourage folks to add some questions to the chat here because I know there are many. I know I've talked to a few folks offline just from this webinar alone, and of course appreciate any insight Daniel and Evan might have. In the meantime, I'll share a few that I've gotten offline before that I thought you all might be able to answer, and perhaps some in this group here might be interested in. And I think my first question here kind of actually gets at the first comment that was added to the chat by Jason. So Jason had asked, is it realistic to think that the 120 days is enough time to legislate, tax, et cetera, these machines to allow them to remain. And we talk often, Lauren and I and the PRLA team. It's a divided government in Harrisburg. It's difficult it's difficult for progress sometimes, and it's even difficult to pass things like bridge naming resolutions and that sort of thing at times. Obviously, this is a high-profile case, and they're in Harrisburg. They're going to be in Harrisburg often the next couple of weeks. So if there's ever a chance, now is the chance for them to perhaps do something, especially with the Supreme Court kind of empowering the legislature to kind of take some action or explore some action here. But kind of encouraged by or inspired by Jason's question. But I've also gotten this offline, Daniel and Evan, and Lauren and I were wrestling with this on Friday and this morning. What happens if they don't do anything, right? What happens if we come back? I think mid-October is about 120 days, but let's say we come back in November and just nothing's been done. And so all that's left is the Supreme Court decision. I mean, I'm not a lawyer. Is it as simple to think as, what you guys presented today holds and the machines start getting confiscated or had to have been out already? These are illegal, or is it more complicated than that? What do you all say to that question? What happens if they do nothing? And then, of course, open to any thoughts you might have on Jason's question that he put in the chat.
Yeah. I think we would be left with the Supreme Court's decision in 120 days with the expired stay on enforcement, which essentially means they've been made illegal and time is up to figure out what you're going to do or how you're going to get them removed. It then becomes up to enforcement agencies to come out to enforce compliance with the law. And what I think would be really unfortunate is a situation where they just can't act fast enough, and we have a period following the 120 days where there's 6 months of illegality, and then the legislature comes in to impose a fix. That may also be a possibility, but I'll call it maybe a lost opportunity, because now is the 120-day period they were given to act. And if they don't, there's going to be a very large disruption to a large number of business owners throughout the Commonwealth. I think on the timing, I am skeptical, but there's a lot of money on the table here for the Commonwealth as well. It's not just making something illegal or regulating it. These machines, not that we want to have our profits taken or things like that, but there's an opportunity for the Commonwealth to gain here because they're not taxed and they're not regulated. So I think that if they were to implement something like that, I think that would create the incentive for them to act quickly and to do it now, because if they lose half of the operators following the 120-day stay, they'll just lose out on their potential tax revenue as a result. Daniel, I don't know if you have any different thoughts on that, or Lauren, sorry.
Yeah, I was just going to jump in to say, this is not a new conversation in the legislature. They've been wrestling with this for years. There have been bills introduced for a number of the last, several legislative sessions. Directly following the Supreme Court decision, there were legislative leaders who spoke out and said that they see this issue as critical to resolving this year's state budget, which they are supposed to pass by June 30th, which is in basically a couple of days. Then the June 30th deadline has never stopped them from going far past that deadline, but there certainly is going to be some level of a push to make this, taxation regulation of skill games to one extent or another part of resolving this year's state budget. So, the question of whether it's doable in 120 days, sure. Is it going to be? I don't know, but I think there is going to be at least from some legislative leaders a push to try to resolve that. And to Evan's point, there's certainly a lot of money on the table to help fill in some holes in the budget.
Yeah. Thank you both. I just want to add to that, and in the spirit of the decision, the Supreme Court's decision, just be very blunt. And I can tell you, in 120 days, if there isn't a legislative solution, um, or some other stay that is placed by the enforcement agencies, you're operating illegal gambling. And if you have any of these devices on your premises, and it is a misdemeanor of the first degree under 5513. 5513 of the Crimes Code, subsection B, specifically addresses what will happen. It says any gambling device possessed or used in violation of this section, subsection A of this section, shall be seized and forfeited to the Commonwealth. So not only are the devices going to be seized, but any money that derives from the devices. Evan and I have this case. We had this case 2 years ago before the Commonwealth Court had decided the Paysomatic case. And the facts are this premises, this client was also a licensed premises. So they were also subject to enforcement by the Bureau of Liquor Control Enforcement, which is the state police. And they arrived in the early morning, with basically SWAT gear on and machine guns, and they took the devices. They took them. They put them in their truck, and they took them, and they took money that
And
was in a bag, right? So I just that what could happen is that, right? And I'm not sugarcoating it, but that's what the court said. In 120 days, these devices fall under 5513A of the Crimes Code, and this is what could happen. So there was a question also, is taxes the way to go? Just tax the thing and don't do criminal enforcement. Yes, that's a legislative fix, and that certainly could happen. There was another question about, well, will there be another license? Let's call it a small license for restaurants and taverns and gas stations. Yes, that could be a legislative fix as well. Okay, but both of those are legislative fixes. And as I said at the beginning of the presentation, I don't know where the legislator is going to go on this. There's a question about me skipping some slides. I'm sure we can make all the slides available to anybody on this presentation, probably by email. So sorry if I skip some slides. Yeah, at the very start of their opinion, the court said, they said, to put it more plainly, how this court feels about access to skill games or other types of slot machines, or about how the broader legislation or normalization of gambling in our society, for that matter, is irrelevant. So can we tax it? Is it making a lot of money? Are we in 2026, and should seeing, slot machines next to the in the grocery store, next to milk, should that be normal? The court said, look, we don't have an opinion on that, and it's irrelevant, for purpose of this decision. So.
Daniel, I'll jump in just to share. I think the awkward I think there's something awkward about the stay, and I don't know if it was intentional or just I don't know if stays are normally 120 days or if there's anything normal about this, Daniel. But obviously that brings us that the clock will have expired just before a major election, right? Which is following that in November, right? And so to the spirit of some of these questions that are being asked, I think. That the tax aspect of this is arguably one of the biggest variables in the conversation that's happening, not just what that tax rate might look like. And Lauren can keep me honest here if I'm wrong, but I think the governor's been proposing something north of 50% ish in the tax range, and there's probably a whole lot others who can't even get up to 20 or 30% right now. But in addition to just what the rate looks like, legislators have to also have a conversation about where those tax dollars go and what happens with that additional revenue, right? Which could, completely blow up a conversation. And then the question is, as a lobbyist and folks who, as a government affairs professional, I think a lot of us are asking the question of, do folks want to have that conversation before major elections in November? But I will say the legislature is able to act quickly when they want to, especially on, when there's a deadline or a sunset or something like that on the horizon. And so they've got that, in front of them. Daniel, we could certainly make slides available to attendees, and I'm not sure which slide we might have passed over, but we could definitely distribute that when our team sends out the recording of all of this. Daniel, a question I've gotten offline before, and it's kind of embodied and baked into some of the questions we're getting here is, what might enforcement look like in terms of who's doing the enforcing, and are there things that folks on this call ought to consider, in terms of, differences between, the state police, right, or the LCB, and those that have liquor licenses versus those that do not. Eric, I think it's slide number 9 that was flagged, so I don't know if that's something we could go back to while we're having this conversation. But yeah, I think Jason hit it most recently, Daniel and Evan, where he says, could you discuss the possible PLCB stance and any possible effect on liquor licenses? But also anything you guys have to add in terms of, what restaurants ought to consider, those that have licenses versus those that don't? Is this just a state police issue? Can there be district attorneys that start swooping in? Can certain counties be handling this differently than other counties? What should people be thinking about there?
I
Go
mean,
ahead.
you have some thought on the 120 days. We were just talking about it. Do you want to share your thoughts on the 120 days?
Well, I think there's these are hard questions because we don't know all of these answers, but we do have a lens toward what this could look like, because before the Supreme Court decision and before we had good clarity from the Commonwealth Court, the Bureau of Liquor Control Enforcement was going out and they were enforcing against certain kinds of skill games that they deemed to be more chance related. And it was, as Daniel described, it wasn't a polite knock on the door like LCE is more typically known to be like. This involved I think, month plus long investigation where the officer was actually in the premises playing skill games and undercover, obviously, and then later came out with his team and confiscated all the games and all the money, not just some of the money. They took all of this client's money that he had in his store. And I think what concerns me is, and there's a question in the margins here related to PLCB enforcement, and what does that mean in light of this 120-day stay? And what I can say to that is, although the Bureau or PLCB themselves may honor this 120-day stay, it's a question, because there's a difference between a stay of enforcement and what the opinion decided. The opinion decided these are now illegal. And even though there's a stay, you're allowing illegal conduct on your premises, perhaps. That may be the position taken by PLCB or the Bureau, despite the stay. because the stay didn't say there can be no wrongdoing during this 120 days. They just said there's a stay on enforcement. It was also interesting through some of these other experiences we've had before this decision came down. We heard anecdotally that there was no um, township or municipality-based enforcement. And if there was, it was very scant compared to the Bureau of Liquor Control Enforcement. So it created this very unequal playing field for PLCB licensed establishments who were looking two doors down the street and they're saying, well, this guy has the same games that I have, but they didn't go take all of his. Why didn't they do that? Well, that's because you have a liquor license. Sorry, you're on a higher standard as a result, or under higher regulatory burden, perhaps, which is accurate. So unfortunately, that's going to be the position. I would love for the association to keep us in the loop if they do hear of enforcement efforts in the 120-day period, because if that's the case, we need to set off, alarms on this, because it's going to be not alone if they come out to enforce in the 120 days. And the other problem with this 120-day stay for liquor licensees is the effect may not be during the 120 days. They may take the position upon renewal of your license that you were engaged in criminal activity, which may be well outside the 120-day period, and deny renewal or validation as a result of having skill games, which, look, that would be really unfair. It would be really an inconsistent change of how they're enforcing this. But based on what we have today, it's a possibility.
Yeah. Yeah, I could see the PLCB taking the position on a renewal that because you received a citation for him having a gambling device, whether it gets adjudicated or not, right? Maybe you get the citation in the 120 days, right? And I don't know, maybe it gets dismissed because it was issued in error during those 120 days. I don't know, right? But it's still a citation, that was filed against you for having gambling devices in your premises. I could see the PLCB later on, as Evan explained, during the renewal period saying, oh, the owner of the licensed premises is a person of ill repute, right? Which is what they say when they want to take a position that your license, they want to send you to a hearing, right? What the PLCB would do is through their administrative process is say, okay, your license is not going to be renewed because you are a person of ill repute, and then they will send you to a hearing. Okay, so
Right.
maybe your case,
Can I fill in the blanks there? So
yeah,
to determine that you're a person of ill repute, they use adjudicated citations, but they are also permitted to use other police or illegal activity on the licensed premises. And we've seen instances where they will use an owner's personal criminal history to revoke a license, or they'll use criminal activity that occurred on or about the licensed premises, sometimes in the street. So I think that they could use the fact that you have skill games present against you, even if they don't issue a citation through the Bureau of Liquor Control Enforcement. I mean, that would be concerning because it could come up to, it would surprise you on renewal because you never got any citations for it. And now all of a sudden on renewal, they're trying to say you were engaged in illegal conduct by virtue of having these games. I don't think that they want to shut down all of the licensees that have these right now. But I think what happens after 120 days is going to be more severe than what we might typically expect.
There's a question about VFWs and other nonprofits maybe being safe to continue using these devices. Answer is no. No. That again, that could be a legislative fix. But right now, the way the crimes code reads, it says a person is guilty of a misdemeanor of the first degree. Persons include, I mean, it doesn't say persons except for VFWs, persons except for nonprofits, it just says person. So this applies to a Sheets just as well as it applies to a VFW.
Right. And those licensees have PLCB overlay enforcement, but they also have IRS, I guess, overlay regulatory as a result of their nonprofits. So, I could see a situation where the nonprofit status could be in jeopardy by virtue of having generated revenue from now illegal sources. But again, there's this stay. And what is the stay? I guess if you could read anything, we're glad there's a stay, but we're not exactly putting all of our eggs in that basket. I think there's a little bit of concern over some of these additional ramifications that could occur even during a 120-day stay.
Daniel, Evan, we're getting close to the hour here, and want to be, of course, mindful of your time, and appreciate you all being here with us. I mean, we did have, if there's time, we had one last question here from Jason. Is there a current legal recommendation as to whether a PLCB licensed establishment should cease operations today of these machines? And admittedly, I imagine, Daniel, Evan, somewhat of a loaded question, and I don't know if you guys have any thoughts. I know every operation is different, and every in terms of who's operating and where they're operating and how they're operating, and I know we would encourage folks, of course, to consult with their legal counsel about those granular details. Daniel, Evan, Lauren, any thoughts on Jason's question or any closing remarks here to add?
I think it's risky. I think the 100 days is risky. Evan and I were talking about this, and I think as lawyers, we have to say, the court says these things are illegal. Okay. Now, the court also gave 120 days, but it's risky. And, I don't think on this webinar, on this public call, we want to take a position one way or another, right? Because if you get cited and then you call us, hey, we'll defend you, right? We'll defend you. So it's risky. What do you think, Evan? I mean, we were talking about this 120 days. Like, what does it mean?
Yeah.
I think
That's why I differentiated sort of the advice depending on whether you have a liquor license. Because if you don't have a liquor license, all you're worried about is explicit enforcement by local or state police who are going to come in and say, you're running gambling and you'll have this liability under the crimes code that Daniel mentioned. But that's it. And you're probably safe in the 120 days until that time. But for a licensed operator with Pennsylvania liquor license, not knowing what the position is of liquor control enforcement and whether citations have been issued since that opinion came down, to operators of skill games, we're really at a disadvantage. So all we can do is say the most conservative advice right now for a PLCB operator is not to use them. But I don't know that you need to relocate, because just having them present isn't the crime. So I think there's a way to leave them dormant by unplugging them, and that way you'd be able to show that you didn't have revenue during that period of time. But it is very premature to say what the full scope of consequences are. We can only opine on what we think they could be based on worst case scenario. So a lot of this is worst case scenario type stuff, and then we leave it to you to take these risks, whether you're risk adverse or not, sort of up to you. But I think all we can say today is there's a risk for a PLCB regulated entity to be continuing to generate revenue in this manner.
Evan, Daniel, thank you both so much for joining us today. Thank you for the continued collaboration and partnership with the association. Our team and the association here at PRLA, of course, for our members, will continue to keep everybody posted, and our friends over at Tucker on legislative developments, regulatory developments, any intel or information we're receiving on enforcement, both at the local level, at the state level. If folks have offline questions that they want to reach out to us about, feel free to contact us. With that, I'll turn things over to Lauren here for any, closing comments and to close us out. But thank you all for joining us. Lauren?
Thanks, Zach, and thank you, Evan and Daniel. That was great, and thank you, everyone, for being here. As Zach said, we'll keep everyone informed. I think the legislative conversation on this is probably going to develop pretty quickly over the next week or two, and I'm sure we'll have some updates in the very near future to share. And as things become more clear on that legislative front and what specific proposals they might be looking at, we will certainly keep everyone in the loop on that.
Have a great week, everyone. Thank you for joining us.
Thanks, everyone. See you guys.
Thank you.